Good morning, friends. Today I am going to talk about the concept of gift. Before that, we should know the meaning of property. Property means things owned or proprietary rights in rem. Property can be defined as being the right to possess, use, enjoy, and dispose of a thing. The thing mentioned does not always have a tangible or physical existence. It may be an easement or anything else that can become the subject of private ownership. It may be movable, immovable, tangible, intangible, or any property which can be transferable in accordance with the provisions of the Transfer of Property Act 1882. Transfer of Property Act specifically provides for the transfer of immovable property by one person to another by way of sale, mortgage, lease, gift, etc. Gift is one of the way of transfer of immovable property from one person to another voluntarily and without consideration. The next is definition. Let us see the definition of gift. Generally, gift is a voluntary conveyance. Here, conveyance means the legal process of transferring property from one person to another. That is a conveyance not founded on consideration of money or money's worth. It means transfer of property without consideration, or it is a gratuitous transfer of property from one person to another. Section 122 of the Transfer of Property Act 1882 defines the term gift. It defines that gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another called donee and accepted by or on behalf of the donee. Accepted by on behalf of the. Generally, gift takes place between two living persons. There are two parties, one is called donor and another is called donee. Here the person who makes gift of a property is called donor or transferor, to whom the property is transferred by way of gift by way of gift is called donee. The property must be transferred voluntarily. It means there should not be any fear, coercion, undue influence, fraud, etc. If any of the above elements exists, the gift becomes void. Next is essentials of a valid gift. Number 1, there must be transfer of ownership. Number 2, the ownership must relate to a property in existence. Number 3, the transfer must be without consideration. Number 4, it must have been made voluntarily. Number 5, the donor must be a competent person. Number 6, the transferee must accept the gift. Let us discuss one by one what are the essential elements of a valid gift. The first thing I would like to discuss transfer of ownership. To make a valid gift, there must be a transfer of all the rights and interest in the property by the donor to the donee. It was open to the donor to transfer by gift title and ownership in the property, and at the same time reserve its possession and enjoyment during his lifetime. It may, however, be noted that it is permissible to make conditional gift. The only restriction is that the condition must not be repugnant to any of the provisions of the section 10 to 34 of the Transfer of Property Act 1882. The second essential element is existence of property. In a valid gift, there should be a certain existing movable or immovable property. It may be corporeal, having physical existence, for example land, buildings, furniture or etc. Incorporeal, having no physical existence, for example goodwill, copyright, patent right, etc. The property should be specified, existing, movable or immovable, and transferable under Section 6 of the Transfer of Property Act 1882. The gift of the property which is not in existence on the date of gift is void as per Section 124 of the said Act. Say for example, actionable claim is an existing property and can be validly gifted. In a similar way, a gift by a co-partner of his undivided share in a co-partner property without the consent of all the other is void and unenforceable. The next essential element is without consideration. The gift is gratuitous transfer. Here, consideration means the pecuniary consideration and excludes natural love and affection. A transfer in consideration of natural love and affection or in expectation of spiritual and moral benefit is a valid gift. Next essential element is voluntary transfer. Gift by donor must be a voluntary act. The word voluntarily signifies the exercise of the unfettered free will. The gift must be made with consent, where undue influence and pressure is exercised on the donor. It is not gift made voluntarily. Next essential element of a valid gift is competency of the donor. A donor is the person who makes a gift. He can make a gift of his property. He must be major, sound mind and not disqualified. Minor cannot make gift of property. Persons in fiduciary position cannot make any gift. And lastly, the very important essential element of a gift is acceptance by the donee. A donee is the transferee in a gift. The person to whom the gift is made is known as donee. Donee need not be a sui juris. A gift, therefore, may be made in favor of a minor, but such minor, when he attains the age of majority, may avoid the gift. A gift made can be made an idol. A gift can also be to a child, means the child in whom. Acceptance of a gift need not be expressed. The donee must, however, be ascertainable person or persons. A gift cannot validly be made to the public or society at large, where gift is made in favor of two more persons. All of them take it as a tenant in common. If a gift is made to two or more persons, one of whom is capable of taking and other is not, it has been held that the former will take the whole of the property. The gift must also be accepted by the donee or someone on his behalf. The acceptance may be made during the lifetime of the donor and while he is capable of giving. If the donee dies before the acceptance, it is obvious that the gift deed will be void. If the gift has been accepted but the donor dies before the deed is registered, the transfer may be completed after the donor's death. Gift of immovable property, irrespective of its value, must be made through a registered deed. It must be signed by or on behalf of the donor, attested by at least two competent witnesses. Moving towards another important area, the mode of transfer of property. The firstly, section 123 of the Transfer of Property Act specifically says about the mode of transfer. Number 1, gift can be made in two ways. Number 1, registered documents, and secondly, unregistered documents. In case of immovable property, the transfer must be effected by a registered instrument registered instrument attested by at least two competent witnesses, because the Registration Act compels the registration of immovable property. But in case of movable property, the transfer may be effected by registered instrument or by delivery of property. Option given to the donor, whether it is the registered instrument or by delivery. The next concept is mode of acceptance. Section 125 of the TP Act provides that a donee is the transferee in a gift. He must accept the gift or by someone on his behalf. The acceptance may be made during the lifetime of the donor and while he is capable of giving. If the donee dies before acceptance, the gift becomes void. But a gift may be made to a minor or child in womb, but such minor, when he attains the age of majority, he may avoid or accept the gift. Where a gift of a thing to two or more donees of whom one does not accept it is void only to the extent of those who have not accepted. A gift of a thing to two or more donees of whom one does not accept it is void as to the interest which he would have taken had he accepted. Next is mode of revocation. Section 126 of the Transfer of Property Act provides for the mode of revocation of gift. When gift may be suspended or revoked. Section 126 of the Transfer of Property Act lays down two modes of revocation of gift. Firstly, revocation by mutual agreement of donor and donee, and secondly, revocation by rescission as in the case of contract. Firstly, donor and donee may agree that on the happening of any specified event which does not depend on the will of the donor, a gift shall be suspended or revoked. But a gift which the parties agree shall be revocable wholly or in part at the mere will of the donor is void wholly or in part as the case may be. Say for example, A gives a field to B, reserving to himself with B's assent the right to take back the field in case of B and his descendants dies B and his descendants die before A. B dies without descendants in A's lifetime. A may take back the field. The condition for revocation of gift is a condition subsequent. It must be valid under the provisions of the law given for the conditional transfers. Secondly, in case contract, gift can be rescinded. Gift is a gratuitous transfer of ownership made voluntarily if it could be proved that the gift was not made voluntarily. For example, the consent of the donor was not free. The gift must be revoked. Gift is always preceded by an express or implied contract, offer by donor and acceptance by donee. If the preceding contract itself is rescinded or revoked, there is no question of taking place of transfer made under 8. Transfer made under 8. The next concept is onerous gift. Section 127 of the TP Act provides that this section lays down two types of transfers. First one is single transfers and second is separate transfers, where a gift is in the form of a single transfer to the same person of several things of which one is and the others are not burdened by any obligation. The donee can take nothing by the gift unless he accepts it fully. Where a gift is in the form of two or more separate and independent transfers to the same person of several things, the donee is at liberty to accept one of them and refuse the others, although the former may be beneficial and the latter onerous. Say for example, A is having shares in X and Y company, wherein X company is prosperous company but Y company is in loss. A gives B all his shares in a company's. B refuses to accept shares in Y company. He cannot take the shares in X. In case of separate transfer to same person, in such cases he has option to accept any of them. The next concept is universal donee. Section 128 of the Act provides that, subject to the provisions of Section 127, where a gift consists of the donor's whole property, the donee is personally liable for all the debts due by and liabilities of the donor at the time of the gift to the extent of the property comprised therein. Comprised therein. Gift may consist of donor's whole property. Donee is personally liable for all debts due to the extent of the property comprised. And lastly, the saving of donations, MORTIS, CAUSA and MUHAMMADAN law, section 129 of the Act. Nothing in this chapter relates to gift of movable property made in contemplation of death or shall be deemed to affect any rule of Mohammedan law. Lastly, I would like to conclude that gift is the transfer of any movable or immovable property. To make a valid gift, essential conditions shall be fulfilled in accordance with the provisions of the Transfer of Property Act 1882. Gift is a gratuitous transfer of property to one person to another. Donee may put condition, donor may put condition while making gift. It may be revoked in certain cases. Totally, the concept of gift plays important role in the society.